The committee is resumed. Members, before the dinner break, we were considering the Shop Trading Hours Amendment Bill. The question is that Part 1 stand part, and the Honourable David Cunliffe had just completed his call.
Mr. Chairman.
Well, the Honourable David Cunliffe.
Mr. Chairman, thank you so much. I appreciate it. Mr. Chairman, I'm not going to detain the House for very long, but I will briefly recall the argument as it stood before the dinner break and then just complete it with some clause-by-clause analysis that was put before the Commerce Committee from Regulations Review. Mr. Chairman, before the dinner break, we discussed how the House has on repeated occasions in past years confronted the issue of Easter trading and has manifestly refused on a majority vote to liberalise. And we then noted that the government, in its wisdom, has chosen a different approach on this occasion, which is to sub-delegate to territorial authorities the opportunity by regulation, effectively, to change the law under this Act. We noted that on the advice of the Council of the Regulations Review Committee, that was effectively a Henry VIII provision, which, as you will well know, should be rare, exceptional and only under extraordinary safeguards. It was also noted that officials' advice differed from that on the Henry VIII point, but it remained the view of the Regulations Review Committee. Sir, it was noted that territorial authorities, one after the other in their testimony to the committee, not only said that they did not want the power that was being bestowed upon them, but they found the bylaw process onerous. It was the hope of some members of the committee that on that advice the government would rethink the sub-delegation of the decision and bring it to the House proper for debate. But no, they doubled down on constitutional omission and have put amendments first to the Commerce Committee, which it refused to support on a tied vote, and have now been reintroduced to the House by the Minister through a supplementary order paper. In a quick minute, sir, what I would like to do is deal with the contention that was initially raised by advisers to the committee that the policy-making process effectively had no different protections than the bylaw process. Now, the House will immediately confront the logical inconsistency of that position, because if there were no difference, then there would be no advantage in streamlining the local body process by moving to a policy approach. But in any case, let me note, as the Regulations Review Committee did, some of the differences. The first, which was noted and then set aside, was that the original bill required an explicit Bill of Rights vet, and the amendments do not. However, it was contended that that was implicit anyway, and so there may be little difference in action of that change to Section 5D. However, it is in the change to Section 5E of the Act, in the part we're considering, that the material differences principally arise. Section 5E, for example, requires a meeting of full council to pass a bylaw, but that will not be specifically required to adopt a policy report and release it for consultation. Section 5E required a meeting of a council committee to consider submissions, but the current amendments do not. Section 5E required a meeting of full council to resolve to adopt a bylaw and set a commencement date. The amendments as proposed do not. Section 5E also, in respect of review provisions, set out extensive requirements for the meeting of council committees to consider submissions through a transparent process, and for the full council to resolve, amend, revoke, repeal or continue bylaws that are not required. The amendments as proposed do not. And I could go further, sir, but I think that gives the House and the listening public enough examples to note that the policy approach, while more streamlined, contains fewer constitutional and process protections than the bill as introduced. Now, it may be the contention of the government side and the Minister that that's an improvement, but what I would say as a member of the Commerce Committee that, with others, heard submissions, is that it actually flies in the face of the spirit of the submissions of at least the major metropolitan local authorities, who said they actually did not want to be the decision maker on this matter because they considered it more appropriately a matter for the whole House. And in removing the bylaw protections, actually, we have aggrieved further not only that appropriate sentiment, but also the constitutional issues that are embedded in at least the risk of this being a Henry VIII clause, and I would say that in my personal view, it most definitely is.
The Dr. David